Good morning. Morgan O'Hara back in the studio today, here to answer your legal questions. So if you have something you want to know about, go ahead, get on the phone now, give us a call. Good morning. Thanks for coming back today. We appreciate it.
Thanks for having me.
We've got a couple of callers on the line. Let's go ahead and get right to those. Hi there. You're on the line with Morgan. Go ahead. What's your question?
Hi, Morgan.
Good morning.
I just wondering, if you're renting an apartment and the landlord comes up and says, well, we're going to sell the place, how long do you have before you can have to move out?
Well, generally speaking, I think you're going to want to look at the lease agreement that you've signed. You probably want to take it to an attorney, have an attorney look at the lease agreement. It's probably going to depend upon what your contract is. There may be something where the new complex is going to assume the lease and nothing would change. But I would think you'd want to take that contract to an attorney, have him look at it, to read the fine print to see if there's anything contained in that agreement about if the owner of the complex were to sell it.
And something that I know that a bad habit is reading the fine print. Your recommendation before signing any type of contract, even a lease that you think is standard, there could be something in there you didn't know was there.
Yes, it's always a good idea to read everything very carefully before you sign it. I think a lot of people have the tendency to overlook those things because there's so much to read. But you know, or take it to an attorney and have an attorney look at it to kind of look through it to make sure there's nothing in there that you're not aware of that could come up in some situation that
it's not standard.
Yes,
perhaps.
yes,
okay.
or that could mess things up in the future.
Just a good reminder.
Yes.
Thanks, Morgan. Let's go ahead and take this next caller on the line. Hi there. You're on the line with Morgan.
Yeah,
go ahead. What's your question?
about the conceal and carry law. What's the situation on that? Is it still legal or illegal to carry a gun?
My understanding is that there's still that we do in Kansas have a conceal and carry law. That's my understanding right now. You'd have to get licensed and certified and be able to get that permit to have a conceal and carry. So it is my understanding that under Kansas law, we still do have a conceal and carry permit.
If you are caught carrying or have a weapon that you have no license for, are there any type of charges? Do you guys deal with any of those cases?
Yes, there can be charges. A lot of times, sometimes what will happen is like somebody will get pulled over and they'll have some sort of weapon in their vehicle or something, and they don't have a conceal and carry, or they don't have you have to have. There's a lot of different laws behind it without getting into all the details, but usually you have to have it concealed in something. And a lot of times people don't have it concealed if they get pulled over, but you've got to have some sort of permit to be able to be walking around carrying a gun. Yes.
Or you can be charged with a unlawful possession of a firearm.
Well, there's a lot of different things that can go into it. I mean, a lot of times people, an unlawful possession of a firearm can sometimes be like if you're a felon and you're not supposed to have a firearm in your possession at all. But a conceal and carry is to be able to walk around carrying a gun. The car thing that I was talking about, a lot of times that's involved in making sure somebody, if you have a weapon, that you have it concealed in something in your car. There's different laws for different things that you're trying to do in a car, or if you're just walking around carrying a gun.
Okay,
yes.
Thanks, Morgan. Let's go ahead and take this last caller on the line. Hi there. You're on the line with Morgan. What's your question?
Okay, we have a land contract, and we talked to the owner. We're aware of the fact that we're behind, and we had a verbal agreement with him that he was going to wait until I got my back payment from Social Security in before he did anything, and we were going to refinance the house. Well, last week I got a paper in the mail that he already filed with an attorney for an eviction, and we go to court on 18th. Is this something that I should bring up in the court, the fact that we had a verbal agreement already in place?
Yes. Yes, the answer would, you should definitely bring that up. A verbal agreement can be enforceable. You're going to have to be able to prove it. So, you know, I don't know if you had a verbal agreement, you acted upon that agreement, if he acted upon the agreement in some way. Honestly, you probably really need to get in contact with an attorney. If he's got an attorney, it also would be good for you to show up in court with an attorney. But a verbal agreement can be enforceable. The problem sometimes is being able to prove that you had an agreement, because I don't know if he's going to say that we didn't have one. So a lot of times, if people are following through with that agreement, that would be a proof that you did have a verbal agreement.
Okay, thanks so much. Good to know. Great questions. And if you didn't get on the line this week, well, we'll have someone back here next Wednesday. We'll see you next time.
Thank you.
Have a
Thank
good
you very
weekend.
much. You
And
too.
we'll be back with more Eyewitness News next.